evening and welcome once again to our Carinine Hour, in which we discuss matters related to the development of our beloved Bahama land. Last week we started a discussion about the answers to the question what kind of country we are trying to build here in the Bahamas, and we indicated that it must first of all be a place in which democracy reigns supreme. It must be a democratic place. So we are this evening going to look at one of the pillars of democracy, that is the rule of law, sort of going back to the old theme of sort of law and order. But to have a democratic society, one must have a strong legal footing for the well ordering of the society. So for our guest this evening, we have the Minister of State and Legal Affairs, Damian Gomez, to join us. So welcome to us, and I trust you'll be able to help us to look at the rule of law here in the Bahamas.
Thank you very much for having me. I will do my best.
In terms of looking at the rule of law as being essential to peace and harmony in any democracy, how does our legal system work? It's entrenched, first of all, then, in the Constitution?
Well, the rule of law is basic to the Constitution. Mm-hmm. It's basic to any system of law in which the citizenry assert rights as between them and the state, or as between them and one another. Mm-hmm. For state functionaries, for instance, the exercise of any power has to relate to some legal rule, mm-hmm. so that no one has the capricious ability to impact adversely someone else. Everything is undergirded by rules which may take the form of the common law, or may emanate from statute or subsidiary legislation. Mm-hmm. And even with respect to powers that are granted in statute or subsidiary legislation, there are rules governing the rational exercise of those powers and the proportional use of those powers to achieve statutory objectives, so that no one is faced with a dictator. Everything is, how should I put it, tailored with a backdrop of questions of reasonableness or rationality. And the whole construct of administrative law is geared towards ensuring that statutory and other state functionaries adhere to a certain rational basis for whatever they do. And they are subject at all times to the Supreme Court's jurisdiction.
So no one is above the law.
And no one is above the law.
No.
In fact, the Constitution itself presupposes that by asserting that it is the supreme law of the Commonwealth of the Bahamas at Article 3, and that any law which contradicts the provisions of the Constitution is void to the extent of its inconsistency with the Constitution. And from that, we are able to give teeth to Articles 15 through 27 of the Constitution, which deal with the Bill of Rights. So the right to life, the right to liberty, the right to privacy of one's home and of one's family life, the right to property, the right to freedom of association, the right to join a trade union. All of these rights and the right to a fair trial on both the criminal and civil side, these rights are undergirded by the principle that the rule of law applies and that the Constitution is itself the supreme rule of law. And in fact, in a Jamaican case, Highlands and the Queen, where the Jamaican Parliament had passed laws to establish a gun court, certain aspects of the gun court undermined the independence of the judiciary. And to the extent that it did so, the legislation was struck down as being null and void. So we've got examples of that throughout the jurisprudence of the English-speaking Caribbean, including the Bahamas.
But to what extent, in the public domain, to what extent is the scope of the Constitution really appreciated by the average Bahamian?
Well, we are fortunate in the sense that much of the litigation on the Bill of Rights in the region has emanated from activities in the Bahamas. We have had a fairly robust public law bar. People like Maurice Clinton, now QC, Fred Smith, Lester Mortimer, myself. A lot of matters have been taken up and they've gone to the Privy Council on numerous occasions and have helped this region develop the jurisprudence which we now enjoy in this area of the law.
But I just wondered in terms of
the average man. I suspect that the average man knows more about it than he or she would be given credit for, though the bar could do more to advertise in pamphlets and other forms of media the rights which people enjoy, the remedies which are available to protect those rights. Those would be found, for instance, in Article 28 of the Constitution. We need to have a more engaged, professional bar that looks to simplifying and explaining to the public the fairly complex myriad of rules which, in a real sense, ensure that the quality of life which we enjoy is enjoyed by us.
So the rights and privileges which are outlined in the Constitution need to be presented to the general public in language that is readily understood, is to enable them to have a better idea of what they are entitled to.
Yeah. In fact, the jargon use that typified much of legalese over the ages is being jettisoned in places like England, where things are radically being simplified in everyday English. And the whole ethos of this is accessibility to justice. So citizens from all walks of life and from all educational backgrounds ought to be able to access the court, first of all, by understanding what the law is and what it means for their respective interests. And unless you simplify it and ensure that it is meaningfully understood by all, you do not have the achievement of the equal access to the courts.
And that's something that is rather important. I mean, not only from a legal point of view, for example, in the Old Testament, the 8th century prophets certainly emphasize the lack of justice in the system, that the rich were privileged, and they lamented the fact that the poor were without justice because they didn't have the means to access the system.
But this is what we in modern law are attempting to achieve for the public. Our Constitution, for instance, does not mandate a particular process by which constitutional challenges may be taken, so that it is possible for a person to write a letter to a judge. And once the judge is able to discern the constitutional issue which is raised, that is sufficient. Not that we are encouraging laxity, but that is the gravamen of where we are in terms of the provisions of the Constitution and the jurisprudence which applies to it.
But don't you think that right in our context that we tend to face the same problem that the 8th century prophets were addressing, that in the Bahamas today there are the privileged and the not so privileged. And persons with means would have an easier access to the court than those without means.
Well, they have an advantage in the sense that legal services are expensive, and to engage a lawyer normally costs more than what an average citizen would make, particularly now in these difficult times. However, attempts are being made to simplify things so that in certain instances where you don't need a lawyer, you're able to proceed in the absence of one. But generally speaking, access to justice issues in the Bahamas need to focus more on enabling citizens to access the court without necessarily having to engage formal legal services.
Good, well at this point we must take our first break for the evening.